Hi, I'm Manny Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer. And in this video series entitled Dangerous Business Practices in a Seller's Market, I am joined by my friend
Paul Blumenstetter, RE/MAX Integrity, designated broker owner.
And in today's video, Paul, I want to tell you something that I am seeing so often in the offer instructions that are forwarded to me as a legal hotline lawyer, and it's mind-numbing. I'm seeing an instruction from the listing broker, or a suggestion, however you want to phrase it, that the buyer write their offer, including a term that says that the buyer's earnest money will be released to the seller upon mutual acceptance. Have you ever seen that?
We see it all the time, and I think it's probably one of the most egregious things that listing broker sellers can do. It's not, to me, it's a violation of agency law because you're not treating people fairly and honestly, and you're taking action that's detrimental to your buyer if you're a buyer's broker, suggesting or recommending that they do exactly that. And for one thing that I always tell my agents is if you're going to allow your buyer to release earnest money, you need it in writing that you advise strenuously against that, and that they should seek legal advice from an attorney.
I agree with Paul. There's all kinds of risks inherent from the buyer's perspective of releasing the earnest money. And what I see all the time, brokers, it's risky to the buyers, it's more risky to the buyer brokers, and it's more risky to the listing brokers. The brokers who are drafting the purchase and sale agreement, who are held to the standard of care of a lawyer when they draft the purchase and sale agreement, because what I see all the time is that the purchase and sale agreement includes some opportunity for buyer to recover the earnest money if buyer can't perform, and a statement that the earnest money is either non-refundable or that it's non-refundable and released to the seller. And every single transaction says in the language of the agreement that the earnest money will be returned to the buyer if something happens. And we'll talk about that in a minute. Even if we don't go there, many transactions include contingencies that benefit buyer. Absolutely. And say that the earnest money is non-refundable or released to the seller. Do you agree with that?
Absolutely. And what's happening is the listing broker is giving the seller a false sense of security, because if they think the buyer has released the earnest money to them, then the money's theirs, and the money is not theirs. And in case the buyer should default, legally speaking, they have a right to that money back. But sellers don't see it that way. They think it's their money now.
Yeah, when a buyer is required to release the earnest money to the seller upon mutual acceptance, it's effectively a signing bonus for the seller. That's how it's treated. But legally, it's not a signing bonus, it's earnest money, and some brokers like to dress it up by calling it a deposit. You can't convert this issue to eliminate problems by changing the word from earnest money to deposit. A deposit towards what? A deposit towards the buyer's purchase of the property. What if buyer is never able to purchase the property because of a contingency benefiting the buyer? Or let's say there are no contingencies at all. Are there any statutory rights that might give a buyer the ability to terminate a transaction?
You're the legal expert on that. You'd have to answer that.
There's the Seller's Disclosure Act. That's a statute that creates a statutory right for the buyer to terminate the transaction in some circumstances.
Correct.
There's the Condominium Act that creates a statutory right for the buyer to terminate in certain circumstances. There's Wakayawa, the new statute.
Correct.
Washington Uniform Common Interest Ownership Act that gives the buyer the right to terminate the transaction in some circumstances. So yes, even if there's not a contingency by term, there still could be a statutory right for some buyers to terminate the transaction. And then we get to the final one. I told you there's a boilerplate provision that gives every buyer in every statewide form transaction the right to recover the earnest money if
the buyer defaults on the transaction.
I'm sorry, no, the buyer gets the right to recover the earnest money if the seller.
If the seller defaults, yes.
Yeah. The seller's required to provide marketable title. What happens if the seller can't provide marketable title?
And then the buyer has options available to them for any remedies that they can that are available to them, such as closing, forcing the sale, compensation for buying the property, being able to continue on the property.
Yeah, the statewide form says that the buyer has the right to close the transaction with the title in its unmarketable condition, or if they choose not to do that, or more likely if the lender prohibits them from doing that, then their only remedy at that point is to terminate the transaction, take their earnest money, and go home. So, buyer broker and listing broker, where does this leave your client? If the seller can't perform, can't deliver marketable title in time for closing, and the buyer is entitled to terminate and recover the earnest money, but based on your drafting of the agreement, whether you're the buyer or the listing broker, buyer broker or the listing broker, your drafting of the agreement, now the parties have to do what in order for the buyer to recover the earnest money? Let's say seller spent it. Let's say seller doesn't have it. Let's say seller says, no, I'm not going to return it because listing broker, you told me this was mine no matter what. We've now got two parties in litigation. Why? Because of your drafting of the purchase and sale agreement.
Absolutely. It's the worst possible thing that a buyer broker can do is to allow a buyer to release their earnest money to a seller. And I repeat that if that's a decision that the buyer makes over the advice of their broker, they need to seek legal advice, and you need to get it in writing that that they did that against your advice and recommendations.
Yeah, and even if buyers aren't releasing the earnest money to the seller, way too often I see the reference to non-refundable earnest money. Based on all of the examples we just gave, I don't even know what non-refundable could possibly mean in an agreement. Paul, if we really want to make, as a listing broker, if you want to make earnest money non-refundable, what do you do as a listing broker?
I don't think there's any way you can make it non-refundable. There's absolutely no language that you could write that would allow earnest money to be truly non-refundable. There's always an out for the buyer, either statutorily, as you referred to, or through the terms of and provisions of the purchase and sale agreement itself. It just isn't possible.
But you can do something if we assume seller provides marketable title.
Yes.
What could you do as a listing broker in drafting the agreement? Again, you can't account for the statutory outs, but from the terms of the agreement itself, how can you make the earnest money non-refundable without ever using the words non-refundable?
By removing all contingencies. That's the only way you can do it. There can be no contingencies left in the purchase and sale agreement.
Yeah. Buyer has no contingencies and fails to perform. If they don't have a statutory remedy, and if seller has provided marketable title for a timely closing, then buyer is in default, and that's the purpose of earnest money. The default provision, if it's marked forfeiture of earnest money, says that if buyer fails to perform, buyer is in default. Buyer forfeits the earnest money to seller. That's the boilerplate language of the statute. So again, held to the standard of care of a lawyer, when you go beyond the boilerplate language and write your own non-refundable provision or write release to seller, then you are drafting contract language to subvert the standardized, lawyer-approved boilerplate language of the statewide forms. Do you think that if there was a non-refundable earnest money provision that made sense, that the lawyers who draft the statewide forms couldn't draft that provision for you? Do you think if there was a provision that made sense for the earnest money to be released to the seller prior to closing, that the lawyers who draft the statewide forms couldn't draft that provision for you? Certainly they could. The provision doesn't make sense. The earnest money does not belong to the seller unless and until it is forfeited by the buyer due to a failure of performance. Can't say it any more simply than that.
And you really think about it, there is no upside to a seller or a listing broker asking for non-refundable earnest money. You're putting yourself in jeopardy for something that can't happen anyway. So it really makes no sense to even propose or request or suggest that happen.
Yeah, because believe me, even if you say if you're the listing broker and you say to the seller, now we're going to write non-refundable in here, but of course, in the following circumstances, it's not really non-refundable. What's the seller going to hear? The seller's going to hear a listing broker say, this earnest money is yours, you get it now no matter what.
And that's probably more accurate to what the listing broker is telling the seller.
Okay, that is a very, the making earnest money non-refundable, or worse yet, releasing it to the seller prior to closing, very dangerous regardless of who you represent.
And it's got to be right up there at the top of one of the worst business practices to be doing.
All right, anything else on this topic?
I think that's it.
If you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.